Hi everyone, this is Sean. In today's video, I'm going to do a follow-up video to a series of videos that I made that revolve around whether or not your employer can require you to work a 12-hour shift or work more than 8 hours in a work day. If you want more information on that, I'm going to leave links to the relevant videos in the description box. But in today's video, or the video I'm making right now, I'm going to talk about what you can do if you are an employer and you realize after watching these videos that you made a huge mistake. And also, if you're an employee, if you watch my videos and then you realize that there is a huge mistake made, you're wondering what are your rights. So let's talk about that. But before we talk about that, guys, I may mention what are your rights. I may mention the law. Regardless of what I mention, I am not a licensed attorney. This is not legal or professional advice. Gather the information that you collect today and discuss that with somebody who is licensed in your jurisdiction as a licensed attorney. So, number one, if you're an employer or your employer, remember, we need to look at what the work relationship is. If this is a contract relationship, contract relationship, you can have this person work 50 hours in one day. Well, there's no 50 hours in one day. You can make them work 24 hours in one day. But the problem is, in many jurisdictions in the United States, you cannot be a contractor, a contract employee of a security company. Otherwise, you need a private patrol operator or a security company agency license. You can't be a contractor in many jurisdictions in California. Number two is, a lot of these topics I discussed don't involve hospitals. Well, they don't include hospitals. The hospital environment is a regular 12-hour environment. A lot of private security professionals end up arguably providing patient care, and when they cannot argue that they provide patient care, then if they can't argue that, then there's no exemption under this 12-hour workday. You can't push for a 12-hour workday if you're in private security if you don't provide patient care. And in other videos, I talked about how you can frame the issue in your favor of how you provide patient care. Very briefly, you're preventing somebody who's a danger to himself. You're preventing this person from further injury by maybe keeping them under restraints or keeping this person under a safety watch. That's a form of patient care. In my honest opinion, that's what I would argue. Also, we're going to assume that you guys don't belong as part of a labor union or labor agreement. What we're going to talk about right now is what are the options. So look, if you're an employer, if you realize that you've screwed up and you haven't paid your employees, let's just say you have regularly scheduled your employees for 10-hour shifts, or even 12-hour shifts. And then you realize, wait a minute, there was never an Alternative Workweek Agreement. There was never a labor agreement because there was no labor union. So how can you remedy this? And if you're a private security officer, you might be watching this and saying, hey, you know what? I've been screwed over. I never signed anything. Well, first off, if there's already Alternative Workweek Agreement into place, and then you're brand new to the company, you would fall under that older Alternative Workweek Agreement. That's why before you say anything, you should get an attorney to research the subject, because there could have been an Alternative Workweek Agreement that was already filled out. And in another video, which I'll leave a link in the description, I show you how to find that information out if there was an Alternative Workweek Agreement, so you don't look stupid and start arguing a point. Now, I think for an employer, one of the worst case scenarios is you're gonna have to pay overtime to this employee. You're gonna pay penalty fees and interest and pay attorney fees as well. These are all things that you're gonna have to do if you don't remedy this issue, or if you do go to court. You're not only gonna have to pay back pay, but you're gonna have to pay all these other things that I just mentioned. As an employee, you're gonna have to fork out money for a licensed attorney. Now, some attorneys work on a contingency basis, others don't. But if you work on a contingency basis, basically, your attorney is going to get a percentage of money that's won from the lawsuit, and you guys, some of that money could be money that's payable to you, especially if attorney fees are not awarded. So I don't think it's always a win-win situation. And also, for these court cases to settle, it could take years. If it goes to the California Supreme Court, I mean, they rarely do, but if it does, I mean, you're looking at 6, 7 years or even more. Supreme Court cases tend to take about 8 to 10 years. So is it worth it? And then you might lose. And by the way, if you lose in a lawsuit, there's always opportunity that the judge is going to grant a judgment against you. Like you're going to actually, you might have to pay the defendant for all the money that they spent on an attorney and other legal fees. So it's not always a good thing to just go out there and sue your employer. Now, if there was a mistake made, this is what I recommend, you guys. If you're an employer, talk to a licensed attorney, but I would just pay off your employee. I mean, don't give them a percentage of what is payable. Whatever is payable to them, just write a check to them and pay them, and then have them sign basically a settlement agreement agreeing that they will not, they won't take you to court. I did that with one of my previous employers. Actually, they're the ones that brought up the issue that they made a mistake of assigning us to 3 12-hour shifts, and they had a signed agreement that we're not going to sue them, and in exchange, we'll get all of our hours that we're due, and we got all of our hours. I mean, that's all that I wanted. It was pay what was due. So that's what you can do is make a settlement offer, but make sure every hour that is due that you pay your employees for that, you guys. Now, if your employee, it's up to you if you want to take something like this, guys. Something like this just gets settled rather quickly. You don't have to go to court. On a negative note, you might actually end up with more money if you go through with this lawsuit. But what you see on TV, you guys, all these commercials, those are rare days for people to win that amount of money. I just think as an employee, and just thinking neutral on this video, I rather just have whatever is due. Yeah, you can force your employee or employer into paying interest and everything else like that, but there might be a point in time where they might just fight it, you guys, and then you might end up you might actually, as an employee, you might actually lose money fighting this case in court if this case even goes to court. So let me know what you guys' thoughts are. As an employer, what do you think the fairest resolution for something like this? If you're an employer and you realize that you made a huge mistake, how are you going to fix this issue? If you're an employee and you realize that your employer has been not doing their due diligence and not paying you overtime when they should, what is fair? What would be fair to you guys? And that's all I ask for you guys is don't be greedy, be fair. Those of you who are employers, you're going to be reading this. Those of you who are employees of these organizations, you're going to be reading these comments and seeing what other people are saying. So let me know what you guys think. Okay, and that's all I have. If you guys have any questions, comments, concerns, let me know. Please watch all of the other videos that are part of these series. Take care.